Hey guys, Tammy here. And in this video, I'm going to talk about attorney for the children. I'm going to talk about when they're involved in the case, how they get involved in the case, and kind of what that whole process looks like. Okay. It's a little bit different in different jurisdictions. So, state to state, it can vary a little bit. And there's many, many names that this goes by. So we're going to talk about all of that. Before we dive in, let me just remind you, if you like this content, don't forget to hit like on my video. Also subscribe to the channel so that you get notified as new videos are released. And as I've been reminding you all, 70% of you hearing my voice and looking at my face right now are not subscribed. Okay, this helps me. You can help me as I'm helping you. Please hit subscribe on that button. Now, when an attorney for the child gets involved, it's usually in one of a couple different ways. Sometimes the court, the judge, when I say the court, I mean the judge, that's kind of one and the same. The judge will look at the situation and go, you know what, there is just so much conflict here, or there's so many issues here, or I don't really know what's going on. And so we're going to assign an attorney for the children. Sometimes one of the attorneys of either mom or dad will request an attorney for the children because they feel that, it would be of benefit for the children's voices to be heard. Now, one of the things that you have to look at is the other person that's sometimes involved is a child custody evaluator. And I do talk about that a lot too. The difference in these two a lot of times is I think we see a child custody evaluator involved more when the court's concerned about mental health issues, drugs, alcohol, things that are therapeutic, based. We will tend to see a child custody evaluator more. Or for very young children, I think you frequently see a child custody evaluator involved more because the children aren't old enough to communicate yet and talk, which makes, an attorney for them obviously difficult. And I think that child custody evaluator, they're usually a therapist type person. And so I think that person will kind of dig into the family dynamics a little bit more and all of that kind of thing. So there is some strategy involved if you or your attorney is going to request an attorney for the children be appointed. There is a little bit of strategy involved in there, I think, from a legal perspective of figuring out when do I use a child custody evaluator, when do I use an attorney for the children. Now, attorney for the children is something that we tend to see, I would say most typically children between the ages of about, I would say 6 to 12 is the most kind of common range. 6 to 13, somewhere in there. I'm not saying that it doesn't happen if they're above that or below that. I'm just saying that's kind of the most typical age range. And I think that it's because that's the range where kids will kind of start to know that, there's conflict between the parents. There's all this stuff going on. They have their own feelings about it. They don't always feel empowered to talk about it because, if they're younger, your parents are authority figures and all that kind of thing. So it can be really challenging for them to kind of find their voice at that age. And so I think that's when we more commonly will see an attorney for the children involved. Now, let me real quickly tell you that I have seen this go by about 3 or 4 different acronyms that I can think of off the top of my head. I'm in California. Here in California, we call it minors counsel. Okay, that's typically what it's referred to. A couple of the counties do refer to it as what we call a guardian ad litem. And the acronym for that is a GAL. Okay, so guardian ad litem, GAL. Some states do call the attorney for the children a GAL, a guardian ad litem. Some states call it, I think in Maryland, it's called a BIA, a best interest attorney, which is derived from, best interest of the children. statute is where that name comes from. So BIA, minors counsel, guardian ad litem, attorney for the children, there's a few different names it goes by. So just know all of those things all mean the same thing. It just depends state to state on what they refer to it as. When this person is involved with the children, what will normally happen is they will do an interview with parent A, then they will do an interview with parent B, and then they will usually interview the children and try to garner what the children's preferences are. And their role is really to advocate for the children. And yes, for the children to have a voice and for it to be their opinion to be considered. But the attorney for the children also has a duty to consider the best interest of the child. So it's not just the child goes in, says what they want, and now that attorney has to advocate for that thing. It's not like us as adults where we go in and we say, look, I don't care if you think this is going to work or not. I want you to file for full custody, right? Like as an adult, you can put forth that decision and say, this is what I want you to do, and you're paying for that service. You're going to have an attorney or some attorney that will be willing to just do whatever you want them to do for payment of services like that. But an attorney for the children is going to look more at, okay, the children's opinion is a part of this, but generally the age child that they're dealing with, it's not as simple as whatever the child wants and then that's it, no more. Now, I will say that 13 and up, because I know those of you who are in that older age range, if you aren't seeing an attorney for the children, you're probably going, well, why don't we typically see it for children my teenagers' age? And it's because I think that children start to come into their own voice around 13, 14. That's when we see most states start to consider the children's opinion. And so the children are more able to give their own input directly without the need for that attorney for the children to sort of be the buffer to the court system, okay? Because you're not going to take an 8-year-old and have them explain to the court or some other expert what they want. That minors counsel, that attorney for the children, is sort of that buffer against the system to protect the child when they're younger in that way. So a teenager, 13, 14, 15, 16, right? They're going to be able to give their own opinion and their own input directly without having as much need for an attorney to represent them. Now, again, I'm not saying it doesn't ever happen at that age. It does. It's just not as common. We don't see it as often as we see it in kind of that 6 to 12 range. Sometimes you have a situation where you have multiple children in the family and an attorney is assigned for all the children, and your oldest one you might have 16, 13, 10, and 5. That might happen. You might have a wide range, but an attorney for the children is assigned for everybody typically. So that can happen also. When they're under 5, I find that a lot of times the reason we don't see that is because the children just can't talk and communicate at that level. And so there's not really as much input for them to give an attorney for the children at that age. But I will tell you that I do have several cases right now where I've got a client with a 3-year-old. I've got a client with 2 kids that are under 5. I've got one client with a very young child that's like barely 2. They've all got attorney for the children. Now, that's, again, not as common, but I think where we see it in really young children like that is typically when the court or one of the attorneys or whatever feels like, okay, well, there's not really a reason to get a child custody evaluator involved because we don't see drugs, we don't see alcohol, we don't see mental health issues, we don't see any of that, but we see this extremely high level of conflict between the parents to where we just can't sort out what's going on. We need somebody to dig in and figure out what the heck so that we can reach some agreements. And, the court just doesn't have the bandwidth in a hearing to be able to really dig into the details of your case and figure out what should happen or problem solve. And so a lot of times that is the role of minors counsel, is okay, we just have so much conflict going on here. We need an expert to dig in, but we don't really need an evaluator because we don't need that therapeutic side of it. Okay. So you will see that. And again, I do have it in several cases. It's just more commonly that 6 to 12 range. Now, let me just tell you that when you're dealing with this expert, this is just like everybody else that you hear me talk about in the form of experts, where we're not going to go in and throw the other parent under the bus. That's not the goal. Okay, the goal is to frame your concerns in the context of how they affect how certain behaviors or things, situations, if you can frame it in the form of situations instead of something the other parent specifically does, more like a situation that happened, like instead of saying, well, the other parent actually forgets and doesn't even pick up the child from school. Okay, that's like really framing it on the other parent. And you can say it more neutrally where you're saying, I got a call at 3 p.m. The child had not been picked up, right? I'm not even saying the other parent, but obviously we know by who. The child had not been picked up. So I had to drop everything, run over, pick up the child. The child was visibly upset. The child was crying, whatever you're observing. So you want to talk about it in situation form if you can. I know sometimes you have to just say the other parent did or didn't do A, B, C, or D, but you always want to bring it back to how that impacted the child, because that's really the focus for all of these experts and the court is, what is this effect on the child? They're not there to manage the other parent in that way. Now, they're there to make sure that the child is safe with both parents, but they're not there to micromanage our parenting on a very granular level. And I think a lot of times that's what we expect them to do with the other parent. Okay. So really, beyond a safety concern, they're going to kind of live and let live. And so when you're presenting things, you really have to keep bringing it around to how this impacts the child and why that gives you concern for the situation. I hope that's helpful. If you'd like to learn more tips on dealing with an attorney for the children, other experts in your case, or you just have no clue what's going on in your case and you want some help and guidance, you can go to my website, which is www.divorceuniversityonline.com. If you go to /VIP-coaching, there's a link on that page. You can book a time to speak to a member of my staff, learn more about my services, and how I might be able to support you on your custody journey. See you guys next time.
We'll grow in number, fueled by them to see the horizon, turn us to thousands.